Hello, everyone. I think we're going to get started here. Thank you for attending our webinar this morning here in beautiful sunny Vancouver. My name is Darren Penner, and I'm an immigration lawyer here at Boughton Law. I'm joined by my colleagues, Bruce Harwood, who is also an immigration lawyer, and Matthew McCarthy, who practices in labor and employment law. Today, we're going to be talking about foreign workers. I'm going to get us started with a discussion on the ways that you can bring them to Canada. Bruce will then look at compliance and inspections, and Matthew will discuss foreign workers from an employment law perspective. After that, I'll be back for a quick discussion on transitioning foreign workers to permanent residents, and then we'll take some questions. Bruce and Matthew and I will all briefly introduce ourselves as we start our sections. So let's jump right in. As I said, my name is Darren Penner. I'm an immigration lawyer. I began my career practicing in corporate and commercial law and started taking immigration files a few years in. My immigration practice grew quickly, and while I still do some corporate work, it's mostly for my immigration clients who are starting a business in Canada. In my immigration practice, I work with a lot of employers who employ or who want to employ foreign workers. I also assist clients with applications for visas, study permits, and applications for permanent residence, both through the economic permanent residence programs and through family sponsorship. But today we are here to talk about foreign workers. And our talk this morning is geared more towards the construction industry. So we've tailored our topics for that, but there is quite a bit of information that's applicable to all employers who want to bring in foreign workers. So just in terms of a brief just a brief listing on why you might want to recruit foreign workers. The major one is to solve labor shortages. Most of the employers that contact me, that's the issue. You know, they're running into a problem where they've been looking for Canadian workers and they're just unable to find them, or they hire someone who shows up or doesn't show up, and it all ends very quickly. So they start thinking about turning to foreign labor in order to fill that gap. Another reason that it can be a benefit is that the employer will be named on the foreign worker's work permit in many cases. Not applicable if it's an open work permit, but we'll talk more about that later. But in most cases, if you as an employer are helping someone come to Canada, your name's going to be listed as the employer on their work permit. So it's not very easy for them to go and work for somebody else. And then another benefit is just diversifying the workforce. You may have skills that are hard to find in Canada or impossible to find in Canada, and having people coming in from around the world, they bring new experiences and new skills that can enrich a place of work. So in this section, I'm going to spend most of my time talking about LMIA-based work permits. There are some other ways that you can bring in employees, but in the trades, you're not going to use them very much. Work permits and LMIAs go hand in hand, and most work permits are LMIA-based, so that's where I'm going to spend most of my time. But generally speaking, you're going to see LMIA-based work permits that are employer-specific, meaning the employee can only work for you, and then work permits that are issued through the International Mobility Program. We call that the IMP for short, and that program is basically, it covers LMIA exemptions, so times when an employer doesn't have to get an LMIA before hiring an employee. Sometimes IMP work permits are employer specific, meaning the employee can only work for you. Other times they'll be open work permits, which means that the employee can work for anyone. So, labor market impact assessments. LMIA for short, because the labor market impact assessment is too many words to say a lot. So when we're talking about LMIAs, most work permits are issued through the LMIA stream. Basically, it's a two-step process. In the first step, the employer has to go to Service Canada or Employment and Social Development Canada and ask for permission to bring a foreign worker into the market. That part of the process doesn't really include the foreign worker very much. Oftentimes you'll supply the foreign worker's name and that's about it. It's very much an employer-specific or an employer-centric application. They're going to be looking at the employer. Once the LMIA is approved, then the worker can use that LMIA and apply for a work permit in step 2. As I said, work permits issued through this stream are employer specific, so the worker can only work for the employer who's named on the LMIA. And an employer can request an LMIA for one employee or for many employees. Some of our employers just have one specific person that they want to hire. So they'll ask us to prepare an LMIA for that one worker. When the LMIA is issued, then that worker's name is on it, and then the worker applies for the work permit. In other cases, employers approach us and say, you know, we need concrete forms carpenters, and we need 5 of them. We haven't identified them all yet, but we know we have these 5 openings, and that's also possible. So we can apply for a labor market impact assessment and list 5 positions, and once that's approved, then 5 people can apply for work permits based on that LMIA. There is a $1,000 processing fee per worker. So if you're asking for 5 workers, it's going to be a $5,000 processing fee for that. As I mentioned, workers can be identified both before and after an LMIA application is submitted. There are a few different LMIA streams, and I'm not going to talk much about that because we just don't have the time and I don't think it's relevant. But generally speaking, if you are submitting an application for an LMIA through the high wage or low wage LMIA streams, you can leave it unnamed. And then once the LMIA is issued and you start identifying your workers, you can just write into Service Canada and say, yeah, we have somebody for this spot. And they'll send you back a quick document that has the worker's name, and then the worker can use that to apply for the work permit. In terms of LMIA process, this is something that we go through carefully with employers. There are a few different layers to it, and as time goes on, we seem to have more layers added. It always seems to get a little more complicated, but this is where we're at right now. The first thing that needs to happen, if this is a employment position in BC, the first thing that needs to happen is that the employer needs to register with the BC Ministry of Labour to hire foreign workers. This is a fairly new requirement, and it's also something that can hold up the process quite a bit. It came into effect a few years ago. Service Canada started requiring proof that that certificate had been issued at the time when we make the LMIA application about a year and a half ago. And of course, the government agency handling these applications was absolutely flooded at the time, and it started taking 3 months to get these certificates issued. This was really difficult if we were trying to do something quickly. Now it's a bit better. It's usually between a month and a half and 2 months. But we ask people to get this started right away. That's an easy application. It only takes about 10-15 minutes, and it can be done online. There doesn't seem to be an approval process associated with it. It's just a matter of filing it. The next thing we have to do is advertise the position for 4 weeks. It has to be 4 consecutive weeks on a minimum of 3 sites. One of those sites has to be the National Job Bank. We do more. We usually advertise on 6 or 7 sites, just so we're absolutely clear that we've exceeded the minimum advertising requirements. But of course, we have to use National Job Bank, so that's always one we use. One advertising site has to stay running the entire time until the application is completed and decided. So we usually use National Job Bank for that. The other ads can come down after 4 weeks. We do leave some up as well, but one of them has to stay running. The one quick thing about the advertisements, just keeping in mind the amount of time I have here. Employers often come to me and they say, "Well, we did advertise the position. We've had it running for 3 or 4 weeks, so can we use that already?" The answer almost always is no, and the reason is because Service Canada has a very long list of things they want in the advertisement, and it's all very specific. If even one of those things is missing, we generally have to discount that advertising source altogether. So if an employer is advertising a position without an LMIA in mind, they're almost never advertising it in a way that would be compliant with what Service Canada wants. So generally when we start an LMIA, we have to start the advertising. Now, I should say with steps 1 and 2, the certificate to the BC Ministry of Labour to hire foreign workers, we can apply for that while we're doing the advertising. So we can be handling both those things at once. If the wage that you're paying the foreign worker is less than $28.85 per hour, then 2 of the advertising methods must also target underrepresented groups. So newcomers to Canada, youth, people with disabilities, and we have websites that we can use for that, so we're making sure to target those groups. Once the advertising is done and the certificate has been received, then you can submit an application for processing. Generally speaking, in an application, you're going to need to show that the employer operates a legitimate business. There are very specific documents that Service Canada asks for, so that's not one that we usually have to spend a lot of time sweating out. We know what they want, and we just ask you. There's usually 2 or 3 options we ask you, and it's pretty easy to provide those. We have to show that the business has a legitimate need to fill the position. We have to show that the business can afford to pay the worker. And we have to show that the employer was not able to fill the position with a suitable Canadian citizen or permanent resident. And that's through the advertising. We ask for an advertising summary, basically a recruitment summary before we submit the application. And the summary just goes through who applied. They don't want names because that's privacy info. We can't give names of applicants, but we identify them by their initials or by a number. And for every applicant, we say why they weren't suitable for the position. As of April 2024, the processing time is typically 3 to 4 months. At the end of processing, an interview may or may not be required. If an interview is required, this is not an in-person interview, it's a telephone interview. Service Canada always used to interview employers at the end of the LMIA process. About 2 years ago, they stopped doing that. We at times get a request for an interview now, but most of the applications we see just go through with no interview required. If there is an interview, the officer just usually wants to clarify some of the points that I discussed about making sure the business is legitimate, and recruitment and being able to fill the position. So once approved, the LMIA will generally be valid for 6 months. And LMIA validity time has been all over the place since COVID. We've seen them valid for 12 months, 18 months, even 2 years. But right now it's going back to 6 months. So we can expect that LMIAs will be issued and valid for 6 months beginning now. It's important to understand the difference, though, between LMIA validity and work permit duration. If an LMIA is valid for 6 months, it doesn't mean that the work permit is only going to be 6 months long. It just means that the worker needs to apply for a work permit within that 6 months while the LMIA is still valid. As long as the worker does that, makes that application within 6 months, then the work permit will be issued for the duration requested in the LMIA. And the duration is usually 2 years for a lower wage LMIA and 2 or 3 years for a higher wage LMIA. Sometimes we can get 3-year work permits these days. So as I mentioned, the work permit or the LMIA is really the employer's application. Once that is finished, the employer gives the LMIA to the employee, and then it turns to the employee, and the employee makes the work permit application. The the employee is assessed by Immigration, Refugees, and Citizenship Canada based on quite a few things. They need to show that they meet the skills and experience requirements for the position. They need to meet the language requirements. English and French are usually required, so it's going to be one of those two. They have to show that they're not inadmissible to Canada, and that they're likely to leave Canada at the end of their authorized stay. Now, if you, as the employer, are looking to bring on specific employees, you can save a lot of time and maybe some headache down the road by doing some vetting before you send the employee our way for the work permit. As my colleague Matthew will discuss, you can't be too intrusive in questions regarding employee health or circumstances like that, but you can ask whether the employee feels that they're likely to be inadmissible to Canada on any of the following grounds, and you can list criminal convictions, serious medical issues, and they can just say yes or no. And if they say yes, then you can recommend that they talk to the lawyer. And then, of course, when it comes to the skills and experience requirements of the position, you would assess that like you would any other worker, and language requirements. Language is interesting because oftentimes workplaces aren't actually being run in English or French. You know, if someone who speaks a different language hires a bunch of workers who speak the same language, then they're just generally conducting their day in that language, and they might want to bring other workers in. The issue with that is that Service Canada requires that the language of work either be English or French, except in very specific circumstances. You can require a third language in a situation where maybe the worker is dealing with people from a country where that language is spoken as part of their job, so they need to be able to speak the language. But in terms of a work site in Canada, it's going to be almost impossible to convince Service Canada that an English other than language or French should be required. So you want to be looking for workers who, they don't need to be, you know, perfect in English or French, but they need to speak enough in order to understand the job duties and carry out the job duties. And that's something that IRCC will look for when they're assessing the application. The foreign worker's nationality is also important when it comes to application processing, and specifically the place of processing. The nationals of some countries require visas to enter Canada. If the foreign worker requires a visa and they're outside Canada, then the application needs to be submitted online. This is going to be a consideration because it's going to add, you know, if you're thinking how much time is it going to take me to get this worker to the job site, you need to be looking at the amount of time it will take to process the work permit as well. So if you're looking at, say, 6 months for the LMIA, if you hire an employee who needs a visa to come to Canada and they're not already in Canada, you need to also add the time it's going to take IRCC to process the work permit application. And depending on the visa office, I mean, it can be quick, it can be a few months, but some visa offices take closer to a year right now. So that's something you really need to keep in mind. Some foreign nationals are visa exempt. So if the foreign worker is from many places in Europe or Japan or Australia or New Zealand or some other countries that are visa exempt, then they actually have a choice. They can apply online, but they can also come to Canada and apply for a work permit at the border as they enter. So you cut out a huge amount of time there. They get the LMIA. We can usually prepare an application within a week or so. They come to Canada. As they land in their first Canadian airport, they present their application for a work permit, and it's issued while they wait, assuming it's approved. This is going to be Canada Border Services Agency assessing the application, which we call CBSA. You need to keep in mind that even though the application is being presented at the border, the employee still needs to meet the same requirements. They still need to show that they have the required language level, and then they meet the skills and experience requirements for the position. So that I'm almost out of time here, and that's the LMIA and work permit procedure. I'm certainly happy to answer questions about that at the end of the webinar, or contact me later as well. I'm happy to discuss it with you. I wanted to briefly talk about the International Mobility Program, which I'll call the IMP, because there are some opportunities here. Now, trades, as I mentioned, if you're hiring carpenters, plumbers, electricians, HVAC, people in those trades, it's almost always going to be LMIA based, but there may be some opportunity to come in through the International Mobility Program. So as I mentioned, IMP applications are exempt from the requirement to submit to obtain an LMIA. But the foreign worker needs to meet very specific eligibility requirements for the LMIA exemption that we're going for. So some examples, and senior managers are engineers, and engineers are people that we work with in this program all the time. So if you have an engineer that needs to enter as a professional under a free trade agreement, we can facilitate that. Maybe a senior manager from an affiliated business abroad enters as an intercompany transferee, or a worker with high French proficiency enters to work in any position. Those are all situations where you can forego an LMIA and apply for a work permit. The employer is required to submit an electronic job offer and pay a $230 employer compliance fee, but this is done quickly, and there's no separate approval process for that. It's just submit it, get the receipt, give it to the employee, and then they can use it with the work permit application. I will say as well, I didn't have a separate slide on this, but with regard to French-speaking workers, those are workers to look at carefully right now. If you want to recruit foreign workers and you don't already have an idea of where you want to recruit them from, look at French-speaking countries, because Canada has a policy decision where they want to bring French speakers in, and they want them to settle outside of Quebec. Therefore, they're making it relatively easy for French speakers to get jobs. People who can show high French proficiency, basically level 7 and above on our language tests, do not need to have an LMIA. You can basically make them a job offer and submit one of these electronic job offers. We can get an application together and they can come into Canada. If they're visa required, we will still need to submit the application online. We'll need to show that they're likely to leave Canada at the end of their authorized stay, and we'll need to wait through the processing time. But if you hire a French speaker from a country that isn't visa required, like France, for example, then we could get an application ready, and if assuming there's no inadmissibility issues, they could be in the country working very quickly because they could apply at the border. Open work permits, sometimes you'll see that. You'll have a worker come to you and say they already have an open work permit. As long as the work permit is valid, there's no problem employing them. This can happen in situations where the worker is the spouse or common law partner of someone who's working in a high-skilled position, and in some cases is a student. Maybe the worker is already an applicant for permanent resident and they've received a bridging open work permit. Sometimes they've completed post-secondary education in Canada and they've been issued with a post-graduation work permit. And there are other times when the worker is participating in the International Experience Canada program, which we call the Working Holiday Program. That'll generally be people between 18 and 35 who are just coming to Canada to see if they like living here and they have an open work permit. The holder of an open work permit can work for any employee. So just a little more on the International Experience Canada, and I am pretty much out of time, so I'm going to go very quickly here. If you're recruiting from a country that has this option and you're recruiting workers under the age of 30 or 35, it's different for every country, so it's important to understand the agreement in place with that specific country. But if you're recruiting young workers from these countries, they can often get an open work permit of 1 or 2 years. And in some cases, it may be possible to get a second work permit that's tied to the employer. Oftentimes, it'll be an open work permit to start with, though. So it's a good way to bring in employees without doing a lot of work to bring them in, and trying them out and then helping them if you like them. There are some funny rules with the working holiday program. You can't just submit an application for a work permit. You have to receive an invitation to apply. They typically open up the program in December, so everyone registers then, and then they send out rounds of invitations through the year. If you know anybody that wants to get a working holiday visa, it's really important that they register in December of any given year, and then usually IRCC will send out invitations in January or February. But if they register too late, they may have to wait until the following year to come. Provincial nominee program is another tool that we've used quite a bit in the past. The provinces went to the federal government quite a few years ago and said that they wanted to have more input into selecting the people who were immigrating to their provinces. So these provincial nominee programs were born, which we call the PNP. The good thing about PNP is if your worker can get a nomination from a province, it allows the worker to get a work permit and also apply for permanent residence right away. Another good thing is it's much less intrusive for the employer. You do have to provide some information and sign a few forms, but you're not providing the amount of information that you would be providing for an LMIA application. If the employee is already working for you on an open work permit or a closed work permit, you don't have to advertise the position. They can just go straight into the PNP process. And it's something that, over the years has been a tool that we've used quite a bit. At times, we've been recommending this over LMIAs. But the problem right now is that it's very highly competitive. And I'll talk a little bit more about specified draws under this and express entry during my last section. But suffice it to say that the points are so high, people need so many points to get an invitation, that most people, and especially people in the trades, are just not able to get invites because salaries, I feel like salaries really need to be up over 100,000 towards 150,000 a year to get enough points to get an invite. And especially if they're in Metro Vancouver, it makes it much tougher. So I'm not sending many people to the PNP these days, but I'm always including it as a calculation. All right, well, that's basically it for my work permit section. And next we have Bruce on inspections and compliance. You're muted, Bruce.
All right, can everyone hear me now?
Yeah.
Okay. So my name is Bruce Harwood, and I'm a former immigration officer, and I've spent the last 17 years as a lawyer at Boughton. And the practice here has focused always on corporate immigration law, which involves, for the most part, bringing in foreign workers. But we also will look at family class applications and matters of inadmissibility as they arise. One other comment I want to make before we start is that in my slides, I've been using the term Service Canada. Well, more formally, it's known as Employment and Social Development Canada, but Service Canada operates the Temporary Foreign Worker Program, so we have used that for my purposes. And one of the things that employers must be aware of is their obligations for employer compliance. So any Canadian-based employer that who brings in temporary foreign workers to whom they offer employment has a series of obligations which are specifically enumerated in the immigration regulations. There are 30 such obligations right now, and I expect there to be an additional one to which I will refer shortly. And those obligations, if you want to look at them, are set out in Schedule 2 of the immigration regulations in the section marked violations at Table 1. But since there are so many obligations here, I've selected a few key ones which I think are worth discussing. So the key obligations, and if we go to the next slide, thank you. An employer must be actively engaged in the business in which the offer of employment is made. So in effect, if you are an organization with a series of companies and you bring in a an employee to work for you at company A, you cannot switch him over to company B or company C without notifying Service Canada, and you will also have to have the employer-specific work permit changed if there's a different company. Otherwise, you're in violation of the terms and conditions of admission. The employer must also comply with federal or provincial laws that regulate employment in the province in which the foreign national works. So use employment agreements that are compliant with BC law. Yes, Service Canada has now produced a template employment law document, but our advice is that you consult an employment lawyer like our own Matt McCarthy to ensure that it is compliant. Anytime that we get an inquiry about bringing in foreign workers, I ask for a copy of the employment agreement and I forward it on to make sure that Matt has reviewed it before we use it for the purposes of bringing in the foreign worker. Another point is that the employer must provide the temporary foreign worker with employment in the same occupation and with substantially the same wage and working conditions as set out in the offer of employment. If as an employer you change the occupation, wage, or working conditions, it's problematic because it may trigger an inquiry from Service Canada or IRCC, in other words, the Immigration Department. Another employer obligation that I think is worth mentioning is that you, as the employer, must make reasonable efforts to ensure that your employee has access to healthcare services in the event that a foreign national is injured on the job. And while temporary foreign workers are eligible for MSP coverage in the province of British Columbia, if there's a gap between the application and the actual extension of coverage, you as the employer should have a private policy in place to cover them. Another point that may be overlooked is that employers cannot charge an employee with recruitment charges paid to a recruiter. Next slide, please. The employer obligations also include the ability for a period of 6 years, beginning with the initial authorizing date on the work permit, to demonstrate that any information that was forwarded to Service Canada or to IRCC in support of the application for an LMIA-backed work permit or even an LMIA-exempt work permit, you have to ensure that that information is accurate. And it's worth repeating that the information should be retained for 6 years, because you, as the employer of a temporary foreign worker, may be asked to produce information on a random inspection, even when there is no complaint made against the company. On the rare occasions where we've had to address this issue of random inspections, we've had the luxury of having very well-organized employment records from the employer, and we've been able to satisfy either Immigration or Service Canada, as the case may be, that if there was any error, it was simply an inadvertent error, and it has not resulted in any punishment. I also mentioned at the beginning that there were 30 obligations. Well, there may be a new obligation, and that is, as of January 1st, 2024, employers who submit an LMIA application are required to update the wages to reflect the prevailing wage for the occupation in which the foreign worker is employed. Basically, the prevailing wage is the median wage on the job bank for the occupation in which you are employing this foreign worker. I haven't seen that being added to the 30 obligations that are set out in the materials, but I can anticipate that will happen. Otherwise, I don't see the point of basically telling all employers that they have to do this effective January 1st, 2024. Now, if there is a failure to comply with any of these obligations, the employer can be summoned to answer questions and produce documents, and IRCC and or Service Canada can request a third party to produce documents in its possession that relate to the issue of the employer's compliance. So, for example, if there's a dispute over wages and a complaint's been made by a foreign worker to Service Canada that the employer's not living up to its obligations, Service Canada may, or it's Service Canada or the Immigration Department, as the case may be, may demand payroll records, which would be a common request if held by an accountant. And I don't see a problem with disclosing that. However, if there are privileged communications between employer and lawyer that require, in my view, that requires some discussion. And although ultimately it's at the discretion of the employer, I'd be reluctant to release privileged information unless absolutely necessary. This legislation, or portion of the legislation in the Immigration Act and regulations, also has some very draconian measures when it comes to suspicion by Service Canada or immigration that there's been some violation of these obligations. So, to be clear, officers may enter and inspect premises of the employer without a warrant. They may question the employer and employees. They can take photos or video. They can demand access to computers and other electronic devices, and they can copy documents. So it is not a situation that you as an employer want to find yourself in. And as to the consequences of one of these violations, it may result in merely a warning, but there may be a monetary penalty, the amount of which depends on the nature of the violation. So, for example, what is called a type A violation, such as the failure to retain documents, the penalty is based on a point system, and 2 points are awarded for this penalty. And a $500 fine will be issued for a small business. A small business being defined as less than 100 employees or less than 5 million in gross revenues per year. And I'm going to point to one example which has been published on the employer compliance page of Service Canada, where someone ran afoul and the consequences of running afoul of the obligations that they're obligated to uphold. Another point is, in addition to monetary penalties, there can be a prohibition from hiring temporary foreign workers for a period of time, depending on the nature of the violation. And that ban can start at 1 year. It can go up to 10 years. And in certain cases, the legislation makes it permissible for an employer to be permanently banned from recruiting foreign workers. I would suspect that in that case, the abuses of the system and the avoidance of obligations are extreme and have forced Service Canada to take such a harsh measure. And in terms of penalties, as I gave you an example of a penalty, but be aware that penalties can range up to $100,000 to a maximum of $1 million per year. I've never seen that. I'm just telling you that the legislation allows them to try and impose these types of penalties. Now, it's also possible for employers to get relief from the failure to comply with conditions. And that relief may come about from a change in federal or provincial law, a change to a collective agreement, an administrative error, and an error of interpretation made in good faith with respect to obligations to a foreign national, if employer makes compensation to all foreign nationals in the employer's employ who suffer a disadvantage. Now, we have used this relief clause to our advantage. In particular, we had a situation where an employer changed the job description and the wages to reward the quality of the work by the temporary foreign worker, but they didn't disclose it to Service Canada. And when they went to renew the LMIA, they showed the updated changes and received an inspection request from Service Canada. And another method of obtaining relief, which is set out in the regulations, is where an employer has had to make responses to dramatic changes in economic conditions that directly affected the employer's business. It's also possible to make voluntary disclosure. So voluntary disclosure will eliminate monetary penalties if the disclosure is made before any enforcement action is taken. But the legislation makes it clear that even with voluntary disclosure, any acceptance of this disclosure is not automatic. IRCC and Service Canada look at the severity of the impact of the violation and how the violation could impact the Canadian economy and the labor market. In the event that a violation is established, what is going to happen is that a preliminary finding is issued that details the facts, the conditions violated, any warning issued, and any penalty assessed and period of ineligibility to hire foreign workers. Normally, an employer will have 30 days to respond, although extensions for a more measured response will be granted. If the employer's submissions are not accepted, a notice of final determination of a violation of conditions cannot be issued until the expiry period allotted for submissions. If that final notice is issued to the employer, it'll spell out the violation and the monetary penalty. And more importantly, the employer's violation with the employer's identity may be published on a government website. In particular, the government website is you can reach it by looking at IRCC employer non-compliant page. And I raise this because if you were to look at it today, you would see that in February of this year, a numbered company in Surrey, British Columbia was fined $60,000 and banned from hiring foreign workers for a period of 5 years. So Service Canada is active in enforcement, although it's measured and it's not necessarily constant, but it is out there. And if you look at the list of violators, there's not an extensive list, and that list is from across the country. And as I recall, there's only 2 violators that whose transgressions have been published on the publication page. And finally, the violation may result in suspension or revocation of a previously issued LMIA, which will basically void the ability of any other foreign workers that you have to continue working if they came in under that same LMIA process. So in conclusion, I would take this away from this particular part of this presentation. If there is any concern over non-compliance, get some legal advice up front before contacting Service Canada or IRCC, as the case may be. And if possible, see if there's room to attempt voluntary disclosure and avoid any sanctions. So that's my brief summary of employer obligations, and Darren will turn it back to you.
Thanks, Bruce. That's some great information in what is sometimes a minefield for employers and something that is not always obvious when they're starting the process. The process does have teeth to it, and it can come back later. So thank you for all of that information. Now, Matthew, we will turn to you for some employment considerations when hiring foreign workers.
Great. Thank you, Darren. I'm going to go quick in light of time, but briefly, my name is Matthew McCarthy. I am a a labor and employment lawyer here at Boughton. I practice primarily in that area, though I touch on some other adjacent areas like commercial contracts and privacy and things like that occasionally. I'm called to the bar in BC and Ontario, and I provide labor and employment advice across Canada except for Quebec for any employers that have national operations. My comments today are going to come from a pure employment perspective, so that might slightly differ in some respects from the immigration perspective. My priority is basically two things. One is to help employers avoid risk from employment-related liabilities like severance, and then also to help employers run their workplace better by having the right processes in place. So that's, keeping, retaining, or obtaining and retaining good people, and then helping them to manage their workplace efficiently. Next slide, please. So the most important advice that I'm going to give in almost every case, as Bruce already touched on, is this: have employment agreements with all your employees. That includes foreign workers. And yes, I mean construction companies too. I know a lot of construction companies don't like to do this. They think it's not valuable. Trust me, it is. Next slide, please. Why do I say that? Because in Canada, employment agreements are much, much more friendly to employers than they are to employees, as long as they're drafted properly. So the basic template you might find on a website, as Bruce referenced, is probably not going to be all that helpful and not all that useful to you. But a properly drafted employment agreement, i.e. one drafted by me or someone like me, is extremely helpful for a number of reasons. Reducing severance liability is typically the biggest one for most employers. Termination costs can be quite high if you have long service employees or older employees, or and that's something you can greatly limit with the proper termination language. Addressing issues of preconditions or ongoing conditions of employment. So things that you need to do before you can become employed, like criminal background checks and things like that, or ongoing conditions. So you have to maintain a certain license, you have to remain eligible to work in Canada, etc. Putting those in place in a contract is very helpful. Sometimes you want to put in post-employment restrictions on an employee. So it could be something as simple as maintaining the confidentiality of your information or property. It could be relating to intellectual property, or it could be related even in some cases to things like non-competes and non-solicitation agreements. Those can be difficult to enforce, but on certain types of employees, they can be enforceable and they can be a good idea to put in contracts. And then particularly for, I think, employers looking to employ foreign workers, creating repayment obligations for specific issues like work permits. So if in your contract it specifies that a work permit may be deemed a forgivable loan, i.e. an amount that's repayable if certain conditions aren't met, if you fail to work for a certain period of time or something like that. As long as it's drafted correctly, something like that can be characterized as a forgivable loan, which can be recovered at the end of employment, or maybe recoverable, and even possibly could be deducted from earned wages if it's drafted correctly. We should be getting employment agreements for all new employees, including foreign workers. And in some cases, employers may want to consider, if they don't have them already, employment agreements for existing employees. That can happen. You can put them into place. Specific things need to happen. There's additional considerations, but it's something worth considering for many employers. Next, please. The next big issue with respect to foreign workers is remembering that generally speaking, they're going to be covered by the same laws as other workers. So if that's employment standards, human rights, workers' comp, workplace safety, all these issues will generally speaking apply to foreign workers as well. However, I think a lot of employers sometimes take these things for granted because they assume employees know their rights. Most employees do. They understand what this is minimum wage, this is what overtime looks like, etc. Foreign workers, in some cases, may not know their rights or know their obligations under the law. And they may also not know what questions to ask. So it's incumbent on employers to help them learn and understand at least the basics. First of all, it's the right thing to do, I think, from a ethical standpoint, but more importantly, I think for our perspective, it's also the legally responsible thing to do because, next slide, because foreign workers are generally speaking considered to be vulnerable to abuse or unlawful employer behavior. A court or a tribunal or any kind of administrative decision maker is likely to look at a foreign worker as being particularly vulnerable because they don't necessarily know their rights, because they may have certain vulnerabilities with respect to their work permit status, etc. So for that reason, those bodies may be extra protective of those employees. So, for example, minor breaches of an employee right that might normally have very small or no consequences at all to the employer could be treated with much more seriousness when it involves a more vulnerable individual like a foreign worker. the breach might be deemed to be targeted or intentional on the employer's behalf. So an example of this is a recent decision from February of this year. A human rights tribunal, when considering a breach, it was an employment standards breach. They failed to pay a minimum wage to an employee that was a foreign worker. The tribunal found this was also a human rights breach. The reason being, they found that they did this intentionally because the employee didn't understand their minimum wage rights, or if they did, they didn't really think that they could enforce it. So therefore, it was deemed to be a discrimination on the basis of citizenship, in addition to being the employment standards breach. This resulted in additional, significantly additional award against the employer in that case. We should also be mindful with respect to foreign workers, specific human rights issues. For example, foreign workers may have different cultural circumstances or personal circumstances that are less familiar to employers, and that may give rise to the duty to accommodate. For example, religious requirements may be different for certain foreign workers, which might create obligations to accommodate specific days off or specific, specific obligations that apply to religion. Same thing with family status. There could be family status issues that arise more commonly, I would say, with large families that are from a foreign worker. We need to be aware of these obligations and treat them seriously. And there are also certain hiring requirements that can create legal risk from a human rights perspective. As I think Darren mentioned earlier, there's a general rule that you can't ask questions in recruiting or interviewing that would disclose a protected ground under human rights law. So you can't ask a question that's going to disclose something like that would disclose someone's religion, for example. That's a protected ground. So unless there's a bona fide occupational requirement, there's a clear reason why it's connected to the job. Now, if an employee discloses something without us asking, that's totally fine. But for example, unless there was a bona fide reason, we can't generally require that a prospective employee have Canadian work experience in a job posting. That would be considered discriminatory. So if you think there's a bona fide reason in a particular job posting, you should confirm with legal before you post it. Another issue that's pertinent to foreign workers, in a recent Ontario case, it was found that an employer cannot require permanent eligibility to work in Canada as a job condition. So what does that mean? The employer could require you to be eligible to work at the start of employment, and they can require it on an ongoing basis. But at the start of employment in recruitment, we cannot require that you permanently are going to forever be able to work in Canada. Why? Because that would disclose a citizenship status or disclose some kind of immigration status, which could be considered protected under human rights law. Now, that was Ontario law specifically, so it's arguable whether that would be applicable in BC or certain other provinces. Nonetheless, as a best practice, we recommend that's not something that an employer asks. Again, generally speaking, seek legal advice before you post something that you think might be in the gray area. And lastly, I'll comment that you have to be very careful when performance managing or terminating foreign workers where their immigration status is vulnerable. If that immigration status is vulnerable, this can open the door to potential bad faith or punitive damages allegations. Essentially, the employee can say, you're terminating me, and these are all the nasty effects it could have upon me that are much greater than they might have on a regular, a regular employee. So if you're going to performance manage or terminate employees in this situation, again, we suggest that you obtain legal advice before you act. And I'm going to pass it now back to Darren for his final section.
Thank you, Matt. One thing that you mentioned was interesting about employers.
Just one thing? Just one thing?
You mentioned many interesting things. One specifically interesting thing was employers talking to you about situations where employees may be paying them back for some situations where the employer has prepaid immigration expenses for them. So that is, it's a very good point. When it comes to Service Canada and labor market impact assessments, employers have to pay it all. So if it's an LMIA, if it's processing fees for an LMIA or legal fees for an LMIA, there's no sending that back to the employee. But after the LMIA, the employees go and apply for work permits. From an immigration perspective, it is quite proper for an employer to have the employee pay that back. So the employer can either initially pay it on behalf of the employee and request it back all at once, or maybe forgive certain amounts of it based on how long the employee is working for the employer. There are a number of different ways to do it. What I wanted to make clear here is that I'm talking, when we're discussing this with clients, we're talking from an immigration perspective and saying, you know, what you can get away with under our act. It's a great idea to talk to Matt because he may have more insights there. And I think he's saying it's generally possible. But if you are looking at preparing an employment agreement that is going to contain some forgiveness of money that you've paid up front for a worker's open work permit, talk to Matt. Make sure you've got the wording right, and that will all be expected to go smoothly. So for me now, there's just one final section, and it's a quick section on permanent residence. The reason we're discussing this as part of this webinar, which is geared towards employers, is because once you start hiring foreign workers, you'll probably find that many of them don't want to just come to Canada for a year or two and then head back to their country of origin. They're oftentimes bringing their families, they're putting roots down in Canada, they're settling here, they want to stay here. So if they're coming under LMIA-based work permits, there's usually no limit to the number of work permits they can get. They can get 2 years and then an additional 2 years and stay here for quite a long time. But what they really want to do is become permanent residents in those cases. Years ago, before Express Entry, it was just a matter of meeting the program requirements, sending in an application. It might take 3 or 4 years to process, but the person could be expected to become a permanent resident just by having come to Canada and put in the work. These days, the landscape is much, much different. It's all points based. So now if employees come over here and work and they meet the requirements for permanent residence, all that allows them to do is register in Express Entry. And when they register, they're given a score, and the score competes with everyone else who's registered. Every 2 or 3 weeks, IRCC kind of skims the top of the pool and sends out invitations to people who have the highest scores. We're finding that people in construction and trades are having a much more difficult time transitioning from workers to permanent residents these days. And the reason is just because the scores are so competitive. There have been some promising developments. IRCC was issuing specific rounds of invitations catering just to people in the trades. So people who had experience as welders, in HVAC, electricians, plumbers, carpenters. There was a list of 10, and then supervisors in those trades as well. Those people, if they had at least 6 months of experience in the position in the last 3 years, qualified for these specialized rounds of invitations. And because they were specialized, it meant the score was a lot lower for this specialization than it would be in the general pool, and that was an advantage. It's still happening. They haven't issued a round of invitations specifically to construction since December 19th. At that time, the score required was 425. That's not horrible. I think it's possible for tradespeople. It is generally going to require a little bit of post-secondary education, though, and especially if the person isn't well into their 30s, they're still going to be getting a lot of points for age. So it is possible. There is a way to get some extra points as well if they register with Skilled Trades BC and they get a certificate of qualification from Skilled Trades BC. That'll get them some extra Express Entry points. They can get as many as 50 extra points by doing it that way. The other thing then is the provincial nominee program, which I talked about before. And that program's great because workers can use it to get both a work permit and apply for permanent residence right away. The disappointing thing that's happening with the PNP right now is they issue rounds of invitations every week or two, and since early February the score required for people in construction industry has gone up by 5 points every single round. So it was at 70 points I think back at the beginning of the year, and now it's 95. That's a very large difference. By the time points are hitting 95, we're getting to the point where it's going to be difficult to get an invitation to apply for a nomination unless there's something there, unless the worker for some reason has a very high level of education, like a master's level education, or maybe they're working outside the Lower Mainland and they have experience there. Maybe they can speak some French. We come back to the French thing. You know, if you bring in French workers, they may have a much easier time at PNP. But generally speaking, the PNP is difficult, and express entry is also difficult right now. IRCC is under some pressure because there is quite a deadlock growing, a bottleneck, where we have a lot of people who have contributed to Canada for quite a few years now as temporary residents, as workers. Their employers need them, and they have no great way to get through to permanent residence. IRCC understands that, and they may do something about it. Unfortunately, they don't tell us what their plans are, but we could expect at least a few times a year for them to do a slightly bigger round of invitations that at least gets the scores down back into the 400s on a temporary basis, but we just don't know. What I find we need to do these days is meet with people individually. So if you have workers who they're stressed about the PR process, they don't know how they're going to do it, the best thing they can do usually is book a consultation with us, because then we review their specific circumstances, their past work and experience, and all their other qualifications, and we come up with an individualized plan for them. Oftentimes we don't have a surefire way in, but we can at least look at the odds and have a few different options they can go if they need to. So that's really it on transitioning to permanent residence. I will say that we're all happy here to talk further if you have any other questions. We offer consultations if people feel they need a significantly greater amount of advice on any area. And Boughton Law is a full service firm. So if you have any legal issues that aren't necessarily related to employment law or immigration law, feel free to reach out, because we can set you up with someone who can help you. So I think that concludes the instruction part of the webinar, and now we have some time for questions. Carla, did you want to manage the question portion of it?
Sure, not a problem.
Okay.
I could see so far no. Oh, one question 4 minutes ago. I own a restaurant. This is from Kia. I own a restaurant brewery. I have 3 foreign workers whose 2-year work permits are expiring later this year. 2 cooks, 1 food service supervisor. 1, how do I extend their work permits? 2, what are the steps to obtain permanent residency for these 3 workers? And how long till they will be able to get their PR?
Those are great questions. It's a very timely question, because this essentially is what we're being asked right now. I have employees, I want to help them. How long is it going to take to become a PR? What can we do? So if you have employees whose work permits are expiring later this year, it's important to come up with a plan for the LMIA, because as I mentioned before, there's a few different stages to it, and you want to make sure that you're applying for your certificate early, that you're doing your advertising at the appropriate time, and that the advertising is compliant with what Service Canada wants to see. And then you're getting your application submitted far enough in advance so that it can be issued before the work permits expire. Now, there is a way where if you get into a situation where the work permits are expiring and the LMIA hasn't quite been issued yet, the employees can actually put in applications to extend their work permits anyway, and ask the IRCC hold the application for 60 days while you wait for the LMIA to be issued. But either way, it's best to start on the LMIA immediately. So if they are cooks and then food service supervisors, those all sound like high-skilled positions, which is great. Assuming that they are all full-time, so 30 hours a week, then they are getting points for Canadian work experience. If you get them an LMIA, they will also get points for having arranged employment in Canada. So that'll give them extra 50 points. But what we would really need to do when it comes to permanent residence is look at age, level of education, expected English language results, can they speak French, look at how much work and what type of work they've done outside of Canada, and a few other factors. So this is where in a consultation we could meet with those workers and actually come up with a point system and tell them what they need to do or what they should be doing to work towards permanent residence. But in the meantime, if you can get them an LMIA, they'll have a closed work permit, meaning they can only work for you. And if you're happy with them, you can keep them to the point where you could do another LMIA down the road and keep them there for basically as long as you want them there, unless the government changes some rules about that at some time. Years ago, we did have a cap. I can't remember what it was. I think it was something like 5 years for all foreign workers. They removed that, I think, back in 2015. But right now, there is no cap on the amount of time foreign workers can stay under the LMIA program. I hope that answers the question. If there's anything I missed, please let me know.
That was the only question we had so far.
Okay.
Is there anyone else that would like to ask a question? I think that concludes things.
Okay. Well, if anybody does think of a question after, feel free to send it along. We're happy to send back a reply. I know sometimes in these things, you get a whole bunch of information thrown at you. You write it down, you forget a part of it, and then something occurs to you a day later. So if that happens, feel free to send it over. All right, well, I guess that will conclude our webinar. Thank you very much for showing up this morning, and we hope it's been of assistance to everybody.